Hi, I'm Emily, and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, if I was married somewhere else, or if my spouse is not in Connecticut, can I still be divorced here?
So this question relates to what is called subject matter jurisdiction for a divorce in Connecticut. That is the question of whether a court in Connecticut has the authority to issue orders pertaining to this particular subject, that is the divorce, or the dissolution of marriage, as it's called here in Connecticut, between two people. Non-residents of the state of Connecticut may marry in the state, something that was quite common several years ago when laws of same-sex marriages differed from state to state more than they do now, and when parties were willing to travel to Connecticut in order to be married here when the laws were more favorable here. But merely because non-residents can marry here, it doesn't mean that state courts can have the authority to dissolve marriages between two non-residents. Under our state law, courts have subject matter jurisdiction, that is, the ability to actually issue rules and orders related to a particular marriage, as long as certain criteria are satisfied. Number one, one of the parties has to have been a resident for at least 12 months before the judgment of divorce is issued. Or one party was domiciled here at the time of the marriage, moved away, and then returned here with the intention of living here permanently prior to the action being started. Or the cause of the breakdown of the marriage occurred after either party moved into the state of Connecticut. As a practical matter, the 12-month residency rule has to be established before the case goes to judgment. That means that there are some times where an action is filed where a party has only been here, for example, 8 or 9 months, and as long as that 12-month window is satisfied before the case actually goes to judgment, which could be 3 months, 6 months, or almost up to a year from the time the action is filed, as long as that's satisfied, the court would then, at that point in time, have authority to dissolve the marriage. Sometimes the action is started sooner, but as long as that time period is satisfied, most judges will have no issue granting the divorce. The problem then comes when the other party may have started an action in another state or may challenge subject matter jurisdiction early on. And in those issues, you certainly should speak with an attorney about what your rights and obligations are in those particular scenarios. The cases where there are children involved are a little bit different because there are certain other requirements not covered here about the length of time that the children are here in the state of Connecticut in order for a court to issue orders related to those children. So custody orders and parenting orders. And there could be situations where the children have not been here long enough, even though the court may have subject matter jurisdiction over the marriage itself. So to go back to the original question, a divorce can be obtained in the state of Connecticut when only one party lives here and the other party lives somewhere else. In all cases, though, especially in instances where the law differs between jurisdictions, whether it's on equitable division of property or on alimony or on something else, individuals with multi-state issues should consult with an experienced Connecticut family law attorney about whether and how a divorce action could be sustained here in the state and go all the way to judgment successfully.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.